Ladies and gentlemen, Judge Wolfgang Schomburg was the first German judge at the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. Judge Schomburg initially studied law in Berlin, where he passed his first legal state examination at the Free University Berlin in 1971 and the second in 1974. The same year, he became a public prosecutor in Berlin and was judge, eventually senior public prosecutor of Berlin. From 1989 until 1991, he was Undersecretary of State at the Senate Justice Departments in the city-state of Berlin, and until 1995 worked as a lawyer in Berlin. In 1995, he was appointed judge at the Federal Supreme Court. From 1995 until 2000, he was a judge at the Federal Court of Justice in Karlsruhe. In 2007, he resigned from the bench of appeals chamber of the ICTY, asserting that the trial could no longer be given the fair self-representation of the defendant. He's currently editor of Germany's leading commentary on the international cooperation in criminal matters, currently in its 4th edition, published in Munich. Specialized in international criminal law, transnational criminal law, human rights, and mutual cooperation in criminal matters. We very much look forward to your perspectives today, not only as a German lawyer, but also as someone who has really worked at the international arena, at the International Criminal Court and beyond. We very much appreciate you making the trip from Germany to come to Slovenia to be with us today. I would ask you all to please join us in a very, very warm welcome for Judge Wolfgang Schomburg.
Thank you very much for this kind introduction. Excellencies, Prime Minister, ladies and gentlemen, dear colleagues. First of all, let me extend my apologies to the interpreters that I was not able to give a copy of my speech of today, so that they have to follow the words and not a written text due to technical problems. Not only in the air traffic, and I arrived late yesterday. Let me first thank kindly for the invitation to Ljubljana and the extraordinary opportunity to speak before such a prestigious auditorium in Slovenia, a country promoting a very important initiative to create better international criminal law. It is the challenge to speak on a topic that since long is moving me, a human being specialized in criminal matters. In principle, we always come too late. First, a crime is committed. Often the police or the military successfully intervenes to stop a crime from being further committed, and at times the police or the military successfully intervenes to stop a crime from being further committed, and at times after a long and winding procedure, the last word is vested to the judges of last instance, final conviction or acquittal, reaction instead of prevention. In addition, nobody in the past really followed the fundamental principle of rule, and that we are all equal before the law. Far too long it was that there were so many untouchables, high-ranking politicians, people of the military, of the media, and others. However, the picture is not that negative any longer, in particular not when it comes to the so-called international crimes in its narrow sense. In the context of today's meeting, primarily the crime of genocide and other crimes against humanity, which in my mind have to be seen together as crimes against fundamental interests of the global community. Ladies and gentlemen, please understand that I will not go into details of the situation in Syria. Why this? Because for a judge, it is necessary, first of all, to show self-restraint, and it is key, first, to hear the facts. Da mihi factum, dabut tibi jus. give me all the facts, and only then I can give you the law. But I hope that you can translate from my words what I want to say also in relation to Syria. We have to acknowledge that in the last 2 years, decades, also on a transnational level since Nuremberg, for the first time ever in mankind, out of the blue, based on the shame emanating from the omission to protect, international criminal courts and tribunals have been established in the transnational fight against these heinous crimes. When it agreed to the Convention for the Prevention and Punishment of the Crime of Genocide, the General Assembly of the UN also adopted a resolution directing the work begin on a draft statute for such a court. This was the beginning of a visionary work. I refer to you the fundamental article of Vespasian Pella towards an international crime, where he, in a very visionary way, already in 1950 showed us the development that led 50 years later to the adoption of the Rome Statute, of the first permanent international criminal court, eventually a treaty-based international criminal court, unfortunately still confronted with hostility and at least non-cooperation by many and major states. No doubt, this approach undermines the extremely difficult work of the ICC. Nevertheless, in the work of the international ad hoc tribunals and also the tribunals in Sierra Leone and in Cambodia, the underlying law became live and vibrant. No longer merely moot texts in conventions or the discussion of academics on what is customary international law. At the same time, the work of these criminal tribunals has triggered a fruitful synergy with the International Court of Justice, not tasked to adjudicate individual responsibility. In particular, in the application of the Convention on the Prevention and Punishment of the Crime of Genocide in Bosnia and Herzegovina versus Serbia and Montenegro, judgment of 26 February 2007. In particular, the latter decision cannot be underestimated. It stated inter alia, I quote, that not only was genocide prevented because of the deterrent effects of punishment, the duty to prevent genocide had its own autonomous scope, which was both normative and compelling. End of quote. Here we are, even the duty to prevent. Further, already in 1951, the ICJ issued in an advisory opinion stating that the principles of the Anti-Genocide Convention is binding upon all states, i.e., its customary international law. Today, however, I want to limit myself to the challenges of the judiciary in criminal matters. The question still remains, what can be the contribution of the judiciary in the framework of transnational accepted responsibility to prevent? To prevent, not only to describe and sanction these crimes. Thus, it is my honest pleasure to present today some thoughts on the role of the judiciary in this mandatory responsibility to protect. The judiciary, that is not only about international courts or tribunals, but in terms of complementarity and subsidiarity, also regional, sub-regional, and domestic courts. The structure of my contribution flows from this topic. Let me give, at the same time, some examples on what is genocide in reality. what is the fact-finding and what was the fact-finding mission of international tribunals. One thing is to read and discuss a text on genocide. The other side is the reality and to hear about these heinous crimes from victims, their relatives, on a daily basis. I have to be honest and to say that it's difficult to stand this challenge as a judge, a prosecutor, a counsel, or first of all, the interpreters, to be confronted with these words about heinous crimes committed, also in part committed in this area, in the territory of former Yugoslavia. Ladies and gentlemen, what have we achieved as lawmakers and law enforcers on a global scale? Where are the gaps to be filled? Let me first turn to substantive law, genocide. The text of the Genocide Convention of 9 December 1948 is well known. The convention entered into force on 12 January 1951. It has to be recalled that the term genocide did not appear in the Charter of the International Military Tribunal. Instead, the term crimes against humanity was used to deal with persecution and physical extermination of national, ethnic, racial, and religious minorities. As one result of this approach, the United Nations Secretariat composed a draft text, prepared with the assistance of brilliant experts, in particular Raphael Lemkin and Vespasian Pella again. A first compendium was drafted and reworked by a committee set up under the authority of the Economic and Social Council. This draft was the basis of negotiations in the Sixth Committee of the General Assembly, which submitted the final text of the Convention for formal adoption to the General Assembly. Its obligation to prevent genocide dovetails nicely with the responsibility to protect, recognized in 2005 by the United Nations General Assembly and endorsed the following year by Security Council. The definition of genocide set out in its Article 2 is a much reduced version of the text prepared by the Secretariat experts, who have divided genocide into three categories: physical, biological, and cultural genocide. The Sixth Committee voted to exclude cultural genocide from the scope of the Convention, although it subsequently agreed to an exception to this rule, allowing forcible transfer of children from one group to another as a punishable act. The drafter also voted down by a very substantial margin an amendment that sought to add a sixth punishable act to Article 2. It would have enabled prosecution for imposing measures intended to oblige members of a group to abandon their homes in order to escape the threat of subsequent ill treatment. References to these debates have bolstered judicial decisions that essentially exclude ethnic cleansing from the scope of the definition. The unfortunate distinction, the separation of genocide from other crimes against humanity, was born. Highly disputed, in particular in relation to borderline crimes committed on the territory of former Yugoslavia beyond Srebrenica. Let me give two examples justifying, in my mind, such distinction under the law applicable at present. In relation to Prijedor, it was said in the ICTY case, prosecutor versus Milomir Starkic, charged also with genocide, I quote, "Despite the scale of the atrocities, after careful analysis of the facts and the state of mind of the actors, the trial chamber was unable to infer the necessary dolus specialis for genocide. This dolus specialis, or specific intent, to destroy in whole or in part a group as such, being the core crime, the core element of the crime. The trial chamber, however, found that the crimes of persecutions and extermination committed against non-Serbs throughout the municipality constituted the core element of the criminal conduct of Dr. Starkic and meted out a life sentence, which was later on reduced by the appeal chamber to 40 years of imprisonment. It reads in the judgment, in relation to killing of members of the group, the trial chamber is not satisfied that Dr. Starkic possessed the requisite dolus specialis for genocide, but leaves open the question whether he possessed the dolus eventualis for killings which may have been sufficient to satisfy the subjective element of other crimes charged in the indictment. While the trial chamber is satisfied that the common goal of the members of the SDS in the municipality of Prijedor, including Dr. Starkic as president of the municipal assembly, was to establish a Serbian municipality, there is insufficient evidence of an intention to do so by destroying, in part, the Muslim group. Even though Dr. Starkic helped to wage an intense propaganda campaign against Muslims, there is no evidence of the use of hateful terminology by Dr. Starkic himself, from which the dolus specialis could be inferred. Statements made by Dr. Starkic do not publicly advocate killings, and while they reveal an intention to adjust the ethnic composition of Prijedor, the trial chamber is unable to infer an intention to destroy the group. The intention to displace a population is not equivalent to the intention to destroy it. But you can see the close link between genocide and other crimes against humanity. Until today's date, nobody stands finally convicted before the ICTY for having committed genocide. Nevertheless, it's carved in stone that genocide was committed in Srebrenica. It was already mentioned. In the appeals chamber judgment, in the case prosecutor Radislav